Hello, everyone. Welcome to LexTalk World Talk Show presented by Clickaway Creators. Today, we have Ms. Brunda Lavu with us. Brunda is a lawyer whose practice focuses on trademarks and copyright. She pursued her LLM, Masters in Intellectual Property Law, from the University of Washington School of Law, Seattle, USA. While pursuing her LLM, she interned at the Washington Attorney General's office under the Assistant General Attorney in the Trademark and Copyrights Department for about a year, which gave her diverse exposure and a fresh outlook to the evolving area of IPR as a key asset for the clients. Upon returning to India, Brunda worked independently for 2 years, assisting various startups, mid-sized companies on legal matters. Thereafter, she joined an IP boutique law firm in Delhi, where she worked for about 4 years. Recently, in year 2020, she set up her own firm, namely AtlasIP Legal, based out of Gurgaon. She deals with trademark clearances, searches, prospectus of trademarks, applications until the stage of registration of the trademark. Thank you so much for joining us, Brunda. We are pleased to have you with us today.
Hi, Vinay. Thanks so much for the introduction and having me on the
It's
platform.
it's a pleasure to have you on the platform for us as well. I'm sure it's going to be a great session where we will be able to kind of answer a lot of questions that a lot of young legal entrepreneurs, especially who are trying to get into the IPR, umbrella of it, will have these questions. So we'll be able to throw some light on them. But before I kind of get into more technical questions, I'd like to request you if you can please brief us about yourself, about your legal career so far.
Sure, absolutely. I think you've covered in brief what exactly I do and also my journey, but I'll just add a couple of more points in order to uh, give a good idea about my journey so far. So I've always had an inspiration to become a lawyer to start off with. I was inspired by my uncle, who was a senior counsel back then and now a Supreme Court judge. So I was always intrigued about the way the cases are solved and the process, research, and what goes in the decisions of a judge. So I adopted the usual course of doing my 5 year law degree. I took up my law course from Bangalore Institute of Legal Studies, which is based out of Bangalore. During my law school, in one or two moot court competitions, I happened to have worked on the trademark copyright cases. And that's when I started becoming more interested in the intellectual property law side. Therefore, while pursuing my law, I also enrolled for a diploma course in intellectual property law from National Law School, Bangalore. And that's where my journey kind of began, I would say, wherein I was able to understand the nuances of IP law in brief. After graduating from my law school, I practiced in the Andhra Pradesh High Court. That is, back then it was Telangana and Andhra were together. So Hyderabad High Court, I practiced for a year under the senior lawyer, Mr. Adinarayan Rao. Thereafter, so in my 1 year of working in the Andhra Pradesh High Court, I mostly worked on various aspects of law, including constitutional law, civil, and very less of intellectual property law. I had exposure to the IP side. Therefore, I decided to pursue my LLM abroad in intellectual property law, which I completed from Washington School of Law, Seattle, like you mentioned in the intro. While pursuing my LLM, I also interned at the Attorney General's office in Washington in the IP department. So mostly my work, I primarily worked on trademark and copyright matters, apart from other legal matters as well. And I was directly working under the Assistant Attorney General, which enriched my IP knowledge and gave me real good exposure to the practical side of IP. And then when I moved back to India, for about 2 years, I started assisting startups clients on such as privacy policy agreements. And thereafter, I joined uh, IP boutique firm, which is based out of Delhi. And I worked there for about 4 years, where I primarily worked on trademark and copyright, and pretty much um, nothing else. And in the meanwhile, I have been approached by some of the Fortune 500 companies in India for assistance on trademark matters. And that is when I decided that I'm confident to get started with my own firm. And that's how I emerged my law firm, AtlasIP Legal, which is based out of Gurgaon. And in a short span of time, we were able to gain the trust of not just the Indian clients, but also clients from across the world. So we do have clients hailing from most of the countries in the world. So that's where I am right now.
All right, amazing. Thank you so much for giving us that detailed introduction about yourself. How did you start? And I'm pretty much sure that your uncle will be very much proud of you now, because you recently won that global recognition as well in the league in the IP space in Dubai. So I'm sure he must be very proud on you that you kind of followed his footprints, and now you are probably shining yourself. So congratulations on that. And thank you so much for giving us a detailed description about yourself, about your journey so far. I'd like to
Thank
quickly
you.
move
Thank you
on
so
to
much.
the next. Great. So I'd like to quickly move on to the next question. And this really talks about your early days, probably. So if you can help us understand, or if you can help us share maybe something about your one of your most memorable case. Usually people talk about their first case because that's very, very kind of special for any and every lawyer. But we would also like to kind of understand from you about your one of the most memorable cases.
Sure, absolutely. There are many memorable cases. However, I would like to cite something which is very recent. Last year, at the beginning of pandemic, when the court started functioning virtually, we had obtained a temporary injunction for one of our Fortune 500 company clients in a trademark infringement case on the basis that the client's mark is a well-known registered mark. So the registration of a well-known mark itself, it's a new concept which has been introduced with the amendment of the rules of the trademark in 2017. Since our client's mark is a registered well-known trademark, we were able to stop the infringer from continuing to infringe upon our client's well-known mark. Having successfully obtained an ad interim injunction so swiftly, that too in unprecedented times, is something of a memorable nature for me. Although, I mean, we continue to file such cases and also get orders in our favor, but I would like to cite this as one of my memorable cases.
Okay, amazing. I think the most memorable thing about this case is that you were going virtual. I think this is not very usual for a lot of lawyers, and that was right in the middle of pandemic. So I think this is a nice pick amongst some of your other memorable cases. Let's move ahead and get on to the third question quickly, Brunda. And here I'd like to ask you, how do you look at opposition brand enforcement in 2021 and how it's going to change 5 years down the line?
Yes, yes, good question. So, as you're aware, every week the Indian Trademark Office publishes certain number of applications in the Trademark Journal, which are open for opposition. You would be surprised to know that in 2020, and which continues even this year, that I'm just giving an example, which is say out of 2000 trademark applications, on an average, at least 400 applications, this is also just an estimate, are being opposed. So in this regard, I would say that the brand owners are becoming more and more aware regarding brand protection and are opting to file oppositions as a first step to block a mark which is similar to theirs from proceeding towards registration. In the next 5 years to come, with more and more awareness among the brand owners, we may see a surge in the number of opposition cases, and also in the way the brand owners take their brand protection seriously. Also, with the complete digitization of the trademark process and procedure by the Indian Trademark Office, I believe it aims to overcome or reduce the huge backlog of pending opposition cases which we currently have. I'm expecting that the trademark registry will provide a faster turnaround time in all the new proceedings, as well as conclude the pending opposition proceedings with the digitization or the online hearings that are about to be introduced very soon by the trademark registry. And with respect to the brand enforcement, it's interesting to note that some of our clients have reported that their trademarks have been infringed or violated the most online in these 2 years. That's 2020 and still continuing. As more number of businesses are going online, uh, there is more scope for infringement online. So at our firm, coming up with innovative ways to identify such violations or infringements and how best to tackle them. Also, the commercial courts, especially the Delhi, Bombay, including Chennai, Kolkata, have been very proactive in passing swift interim orders in the intellectual property matters, which is a sign of relief for the brand owners. Therefore, yes, we see a trend in the brand enforcement, wherein the brand owners itself are becoming more and more aware. And in the future, 5 years down the lane or later, we would see a good number of cases for the oppositions in order to tackle the brand infringements.
So I think, correct me if I'm wrong, it's to do with more awareness. And obviously people are also getting, the brands are also getting proactive in terms of opposing such, trademarks registrations, right?
Yes, yes, absolutely.
Okay.
It's all about awareness.
Okay, all right, amazing. So I think it's a great news, and I think it's a great learning for all of us that brands are getting more aware, and those young IP enthusiasts or legal professionals who are planning to get into the IPR umbrella, under the IPR umbrella. It's I think for all of us to know that these brands are getting aware. Hence, there is a lot more opportunity than it was probably 5 years before 5 years, and probably 5 years down the line or 10 years down the line, it's going to be even bigger and better, right, Brunda?
Absolutely, absolutely.
All right, amazing. So with that, we'll quickly move on to the next question. Thank you so much for sharing such great insights with us on that particular question, Brunda. And talking about the next question, this is about your observation with respect to timelines on trademark registrations in India, post introduction of Trademark Amendment Rules 2017. Would you please brief us about that?
Sure, sure. So, as per my observation, the Indian Trademark Office, I would say, has become swifter with respect to trademark registration. Relatively, I'm comparing this with, uh, 2 to 3 years, 4 years back. The scenario, which is 4 years back. So I would say in a straightforward case, which means when there are no objections raised by the trademark office and no oppositions are filed by any third party, now we can expect registration of a mark in about 5 to 6 months time, which is pretty quick, even if we compare it with most of the developed countries in the world. Also, with respect to the show cause hearings and prosecution cases, especially in international cases. International cases, I mean the applications that are filed by the international applicants through Madrid, which are designated to India. So even the show cause hearings are being appointed relatively faster, which is uh, anytime between 8 to 14 months in order to keep pace with the rest of the countries in the world. This, for me, is a very significant move with considering the number of applications that are being filed in India, which is pretty large. Also, even during pandemic, because the hearings are being held via video conferencing method by the Indian Trademark Office, the applications are being disposed of without any much pendency, which is also quite remarkable, I would say.
All right, amazing. So I think again, I'd like to kind of quickly, sum it up for all of our viewers that first of all, even in these unprecedented times, the trademark registration has been happening quite swiftly. That's number one that I think Brunda is trying to highlight, and most importantly, I think I would like to pick up what you just said, Brunda, is that. The timelines are at par with a lot of, or maybe most of the developed nations, which is again, is a remarkable step in terms of the industry and for a lot of legal professionals, for a lot of IPR professionals as well, right?
Yeah, I would just like to add that in a
Sure.
straightforward case,
In
and
a straightforward case. Okay. All right. Yeah. I mean, we have to do apples to apples comparison here. So in a straightforward case, obviously. All right. Thank you so much, Brunda. I'll quickly move on to the next question. And I'd like to thank you once again for sharing such great insights on that one. Now, this would be our last question for the session. And here we would like to understand what are considered as strong trademarks for registration and how best to adopt them for one's business.
this is a very important question, although it's the last question, but it's very basic and probably one of the most important steps for attaining registration in India. When a trademark is being adopted by an entity or an individual a, or anybody or a company for their business, it is recommended to adopt strong marks, which are fanciful, arbitrary, or unusual marks in nature. So I'll just explain what these terms mean. Fanciful marks, for example, are something which are invented or coined marks, and they don't necessarily carry any meaning. It can be any randomly invented marks which the brand owner would have come up with, which has no correlation to the descriptive or nature or characteristics of those goods or services. So these examples will give a better idea on what fanciful marks are. For example, Kodak for cameras. Kodak doesn't really have any specific meaning, or it is not a dictionary word. Even Google, for that matter, for online services, Rolex for watches. So these kind of marks are very strong marks because they do have, or they do distinguish the marks from those of other traders in the market, and they are very distinctive marks. Therefore, it is firstly recommended to adopt such kind of marks. However, it is also equally important and highly recommended to conduct a pre-filing search in that particular class of goods or services to determine if this proposed mark already exists on the Indian trademark records, or if somebody is already using that mark in commerce, to eliminate any possibility of adopting a similar mark for the same set of goods or services. So that's one of the most important steps. Also, there's another category of strong marks which are called arbitrary marks. So these marks, although they are generic or commonly used marks or terms in nature, but when they are used for this particular category of goods or services, they are totally unrelated to the nature, quality, or characteristics. Uh, the example will definitely give you a better idea of what I'm trying to say. For example, apple when used for computers. Apple, even though it's a fruit, which is very commonly a common term in used in general parlance, but when it is used for computers, it becomes a strong distinctive mark because nobody would be able to associate computers, Apple for computers. Similarly, Dove for chocolate, soaps is also very distinctive uh, in nature. But provided we do a preliminary search to eliminate any possibility of uh, applying or registering the mark which is already existing earlier by any other entity or individual.
All right. I think those examples really made the life easy for me. But I'm sure a lot of viewers would also be able to understand that in a much more depth. And I really like that Apple example. Nobody could really, even in the wildest thoughts, would have imagined Apple correlating Apple with a computer. That's absolutely right. So that really makes it a strong mark. All right. So thank you so much once again for highlighting those key points and those key areas for all of us. And I'm sure a lot of viewers would be able to learn and take away a lot of key informations from this quick session that we have had with you, Brunda. Once again, thank you so much for sharing those great insights with all of us. And we will look forward to having a chat with you again in the future on some other trending topics in the IPR industry. Till then, thank you so much once again for your time. So for viewers, we had Brunda with us on the session today. If you have more questions related to IPR, anything that you want to know, please share your questions with us in the comment box below, and we will try to have Brunda answering them for you. For now, this is Vinay signing off for LexTalk World Talk Show. Have a good one.